Read is Ryle and Lily. We had the very first time we met, we had a 3-hour meeting, and by the end of that meeting, I just knew she was Lily. But no, we didn't have a chemistry read. We did have chemistry reads with Lily and Atlas's, but we didn't with Ryle and Lily. And so I'm grateful and hopeful that there's chemistry on the screen. So sometimes, during this process, as I'm playing Ryle or as I'm directing, there's just times when maybe, words get stuck. I don't get it out the way that I want to, or we're running out of time, and there's always challenges.
Hey besties, let's talk about something that's been stirring up a lot of attention, because honestly, in my view, Blake lively rushed into a legal move that wasn't just premature, but also a little embarrassing, and I really want to break this all down with you. She's basically demanding the court award her attorney's fees, punitive damages, and even travel expenses under California's Civil Code Section 47.1. But here's the thing. She doesn't want to wait until the larger case is resolved, which is usually the normal process. She's pushing for it right now, before the dust has even settled, and that aggressive timing is exactly why I think she may have miscalculated here. Wayfair, who she's up against, countered her request with a very strong argument. They said that Blake isn't a California resident, the alleged conduct didn't occur in California, and therefore California's Fair Employment and Housing Act, FEHA, simply doesn't apply to her. And you know what? They're not wrong. Courts have consistently said that FEHA doesn't just stretch across the country automatically. It only applies when there's a direct, strong link to California. Let me put that into perspective. If an employee both lives and works in California, then yes, FEHA protections clearly apply. But if someone lives and works entirely outside of California, FEHA usually does not protect them, even if the company they're suing is headquartered in California. The key factor isn't where the employer is based, it's where the employee actually worked, lived, and where the alleged wrongs happened. That's been the stance of both California state courts and federal courts alike, and is a very well-established principle. So, when Blake argued that California law applies simply because Wayfair filed their claims from California, with California lawyers, into a New York court, that reasoning just doesn't hold up. FEHA isn't automatically triggered just because a company happens to be from California. There has to be an actual, concrete California connection to the employee and the conduct. Now, here's something I found particularly interesting. I went back and read through the judge's earlier dismissal order. It was a massive 132 pages. And in that entire document, he never once definitively said which state's laws he was using to make his determinations. That's a really big deal. Why? Because the different parties in this case weren't even aligned. Ryan Reynolds and Sloan were pushing for New York law to apply, while Blake was demanding California law. So there were competing arguments, and the judge essentially refused to make a call at that time. He said the applicable law couldn't be determined without more factual development. In other words, he didn't want to decide too early, and he left it open-ended. That decision matters, because in order for Blake to pursue these damages, the judge first has to settle the choice of law issue. He has to weigh whether New York law or California law should govern. That analysis involves looking at things like where the lawsuit was filed, New York Federal Court, where Blake lives and works, New York, where the alleged reputational damage occurred, again New York, and where the publication, the New York Times, operates, New York. All of those key factors point strongly toward New York. Yes, there are some California ties. Wayfair is based there, their attorneys are from there, and Blake did file a complaint with California's Civil Rights Department. But overall, the balance still leans heavily toward New York. Judges generally apply the law of the state most directly tied to the events, and in this case, that seems to be New York. And the choice of law is everything here. If New York law governs, then Reynolds, Sloan, and Vision PR could go after anti-SLAPP attorneys' fees if they win, but Blake wouldn't be able to claim the extra punitive or treble damages she wants. If California law governs, then Blake could chase treble damages under Section 47.1, but the others would lose their New York anti-SLAPP protections. The judge cannot mix and match, he has to pick one state's law. And since he hasn't done that yet, Blake's motion is basically trying to skip ahead a few chapters in the story. Let's also remember this. When the judge dismissed parts of the case earlier, he specifically told Blake she couldn't come back unless something new developed, like new facts or a formal ruling on the choice of law. But instead of waiting for that to happen, Blake filed this motion as if California law had already been established. She's assuming a conclusion the judge never reached. It's like she's saying, we're already in California law territory, so let's move forward, when in reality, the judge hasn't taken that step. That's why I keep saying this filing looks premature and honestly a bit reckless. Now, let's talk about another huge issue in this case, malice. Under California Civil Code 47.1, Blake can't recover the damages she's asking for unless it's established that she acted without malice. That's a statutory requirement. And here's the catch. No one has made a factual finding on malice yet. The judge dismissed some claims, yes, but dismissal doesn't automatically equal a finding that Blake acted without malice. For that, you need either a trial on the underlying claims or an evidentiary hearing. Without one of those, you simply can't conclude that she lacked malice. Wayfair pointed this out clearly. They told the court that Blake's filing was skipping a step because she hasn't established the necessary factual record. Normally, to test malice, either the case has to go all the way to trial, or at minimum, there has to be an evidentiary hearing where her statements and intentions are analyzed. Blake's attorneys argue that wasn't necessary. They claimed the absence of malice was already clear and didn't require further proof. But that's simply not accurate. The judge hasn't ruled on it, and there's no evidence in the record that firmly supports that claim. At best, Reynolds and Sloan said they had no reason to believe Blake was lying to them. But notice the nuance there. They never said Blake knew she wasn't lying. They only said they trusted her. That is a critical difference. So Blake's entire motion is built on shaky ground. She's basically saying, I didn't act with malice, so I deserve damages now, without the necessary factual foundation. Courts don't just take someone's word for it, especially in a case this complex. It's almost like she's telling the judge, trust me, I had good intentions. But courts don't work on trust alone, they work on evidence. And right now, that evidence hasn't been developed. Another important layer here is how federal judges usually handle damages. They don't typically award treble or punitive damages lightly, especially not under brand new state statutes that haven't been tested in court before. Blake is asking this judge to be the very first to apply California's Section 47.1 in this way. That's a huge ask. She's essentially saying, even though this law hasn't been applied in California courts yet, you should apply it here, in federal court, outside California. That's a massive leap. Federal judges are usually cautious. They don't like to be the first to create precedent, especially with laws that haven't been fully interpreted in their own state courts yet. On top of that, Wayfair also argued that what Blake is really doing here is recycling. She's already filed similar motions for sanctions twice before, and now she's repackaging those same arguments a third time under this new motion for treble damages. That makes it look like she's not just seeking justice, but also trying to generate more publicity and keep pressure on Wayfair in the media. Courts do not look kindly on repetitive motions, especially if they appear to be more about PR than about substance. And speaking of the judge, let's not forget how he handled the earlier dismissal. He relied on some unpublished rulings to justify parts of his order. That's unusual, because unpublished opinions don't carry precedential weight the way published ones do. Federal courts can sometimes use them as persuasive authority, but it's always sensitive because it opens the door to appeals. For example, when he dismissed the civil extortion claim, he cited an unpublished case, Tron v. Eat Club Incorporated, because there wasn't a published case directly on point. He also did something similar with the fair report privilege, leaning on Bond v. Lilly, another unpublished case. He admitted in his order that unpublished opinions don't technically bind California courts, but said they could still be considered persuasive. That kind of reliance makes the ruling more vulnerable to challenge on appeal. This tells us two things. First, the judge is willing to stretch the law to clear cases off his docket. And second, Wayfair absolutely has grounds to appeal if they want, because they could argue he leaned too heavily on unpublished, non-precedential rulings. So, given that history, do we really think the same judge is going to suddenly leap into uncharted territory and award Blake treble damages under a brand new California statute? Honestly, I doubt it. Let's also consider timing. The judge hasn't even ruled on Blake's earlier sanctions motions, some of which date back months. If he hasn't decided on those yet, it seems unlikely he'll suddenly decide this new, more aggressive motion right away. Federal judges tend to avoid piecemeal rulings. They prefer to resolve sanctions and damages issues once the larger case is concluded. So, filing now just makes Blake look impatient and unwilling to follow the judge's instructions about waiting for new developments. At the end of the day, Blake's motion feels rushed, repetitive, and premature. She's asking the judge to make decisions he hasn't even laid the groundwork for, like which state's law applies, whether malice has been established, and whether treble damages are appropriate under an untested statute. It comes across as a strategy designed less for legal success and more for public attention, and that's risky. Judges don't like being pressured or having their instructions ignored. So where does that leave us? Honestly, it leaves Blake in a weaker position than before. She's already been warned by the judge not to jump ahead, and yet here she is, skipping steps and demanding rulings he hasn't prepared to make. That's why I think this motion wasn't just a misstep, it was bad faith. It looks like an attempt to weaponize the court for publicity rather than following proper legal process. And in doing so, she risks not only losing credibility with the judge, but also hurting her chances of success later on. That's my take, besties. I think Blake overplayed her hand here, and it might backfire on her. But what do you think? Do you agree that this was premature and reckless, or do you think she has a chance of convincing the court? Let me know your thoughts in the comments. Make sure to hit the like button, subscribe if you haven't already, and click the notification bell so you don't miss future updates. Thanks for sticking with me through this deep dive, and I'll see you in the next one. Bye, besties.